Good afternoon and welcome to the Maryland Attorney General's COVID-19 Access to Justice Task Force. Today's town hall will be on evictions, court preparation, and mediation. Before we begin the presentation, we would like to introduce the Attorney General to say a few words, and he will be followed by Rena Shah, who's the Executive Director of the Maryland Access to Justice Commission. Mr. Attorney General. You're on mute, sir.
Sorry about that. Thank you, Chijoki. I want to thank especially Rena Shah, who's the co-chair of the task force, and I want to thank our partner, the Maryland Access to Justice Commission. Early on in this pandemic, we knew that it would be more than just a health challenge. We knew that the resulting economic impact would create significant hardships that only the civil justice system could resolve, like missed rent payments leading to eviction notices, disputes over medical or consumer debt, people wrongfully denied public benefits that are necessary to keep families afloat. So today, many of our neighbors are left with the significant challenge of navigating the post-COVID civil justice landscape. And yet, unlike in criminal cases, people dealing with the civil justice system do not have a right to an attorney if they can't afford one. This task force was created to identify the short-term and long-term civil legal issues many of our neighbors are confronting. The most time-sensitive of these is housing and evictions. With Marylanders facing job loss or significant loss of income, we expect a tsunami of eviction proceedings over the next several months. Despite requests from this task force to the court system, to the governor, to extend the moratorium on evictions through the end of the year, no action has been taken. And the stay was lifted at the end of last month, yesterday. Court actions will proceed beginning today. We hope that this town hall will provide those facing eviction with useful information on how to navigate the court process and how to find the resources to assist them in keeping their families housed and safe. Finally, I want to say thanks to every single member of our task force for the incredible amount of time that each of you has given to this issue over the last few months. We hope to be able to achieve some concrete results in the very near future. And in the meantime, this afternoon, I think, will be very helpful, very useful to folks who are facing these crises and to the folks who are trying to help them in working their way out of trouble and staying sheltered and healthy. So thank you very much.
Thank you, Mr. Attorney General. And we'll go to Rena for a few words.
Thank you, Chijioke, and thank you so much, Attorney General Frosh. First, I'd like to thank the Attorney General for his leadership, for taking on this issue. As you mentioned, there are so many civil justice issues, so many legal issues that we don't even see as legal issues, conflicts that COVID-19 has brought that can only be resolved in the civil justice system. So you may be having a conflict with your landlord or a debt collector, or you may be trying to get public benefits, or you may have been quarantined with an abuser, or you may be trying to navigate the probate system if a loved one unfortunately passed. And so we know that there are so many civil legal issues that people are facing right now. And the only thing that I would add to what the Attorney General is saying is that we want to continue to be out there. The Access to Justice Commission is committed to ensuring that the civil justice system is fair and accessible for all Marylanders. So as you navigate this new landscape, because now courts will be remote, you may be joining through a computer versus going physically there, or even if you go physically there, there might be different protocols in place. And so we know this is a challenging time as you face these civil legal issues, but we wanted to know that there's an entire community here who is working very hard together through this task force and through many other ways to make sure that people are going to get the help that they need to get the legal information and also get legal representation. And I want to thank our supporter and our enabler, the Maryland State Bar Association, and also the Attorney General's Office for this opportunity. And now I hand it over to Chijioke again to start the presentation. Thank you all so much.
Thank you, Rena. Just a few housekeeping items before I hand it over to our presenters. The format that we're going to follow today is I'm going to turn it over to our presenters. They're going to make a short presentation that touches on a few important aspects of the process and share some resources that are available to you. While they are speaking, you have the ability to send us questions over the YouTube comment option. And while we might not be able to get through every question, at the end of their presentation, we're going to do our best to answer a few of your questions and give you resources to get more answers if we're not able to get to everything. Our presenters today are Greg Countess and Zephyr Shah. Greg is the Director of Advocacy for Housing and Community Development at Maryland Legal Aid, and Zephyr is an attorney with the Public Justice Center. Both Greg and Zephyr are longtime housing attorneys and have been working to help people in facing eviction or other housing challenges for many years. So we thank them for taking the time to talk to us today. I'll hand it over to Greg and Zephyr.
All right, this is how are you, everybody? So we're here to start. I'll start. Zephyr will pick up and fill in anything that he feels is necessary in order to give you complete information. So the original question is, what do you look for? What do you look out for if you're in a situation where you haven't been able to pay your rent, either because you've had a substantial loss of income, and that income loss was caused because you lost your job or because you had to take time off in order to watch a loved one. But before I start with this, I would just say this to you. If you find yourself in this situation, we ask you, number one, if you receive a summons, please go to court. Number two, there'll be a list of resources at the end of this presentation. Please take advantage of the resources, the resource list, and the ability to be able to contact, whether it be legal service provider or an agency that may be able to help direct you to that or direct you to rental assistance. And number three, please go to court, whether that's in person or remotely. So what do you look out for? First, there are actually at least 4 different types of civil actions that can be filed by the landlord in order to initiate the repossession process in a landlord-tenant situation. Second slide, please. Well, we have them there. Failure to pay rent is one, tenant holding over, breach of lease, and wrongful detainer. And let me describe what each one of those are. In a failure to pay rent action, the landlord is insisting that that rent is due. And it is an action or claim that's made by the landlord when they believe that you haven't paid the full amount of rent that's called for by your rental agreement. Number 2 is a tenant holding over action. In a tenant holding over action, the landlord is insisting at that point that your tenancy has come to an end, either because of the operation of the lease, that is, you've had a lease for a period of time and that period of time has come to an end, or you have what's called a month-to-month tenancy, and the landlord has given the proper notice in order to end that tenancy. In order to initiate the tenant holding over action, the landlord does have to show, in fact, that such a notice was sent to you. Throughout the state, it's 30 days. In Baltimore City and Montgomery County, it's 60 days notice. Next is the breach of lease action. And in a breach of lease action, the landlord is claiming that though you have the right to stay in the apartment for a period of time, sometime during the middle of that particular term, the landlord has determined that you have violated one of the essential provisions of the lease. And so the landlord files this action saying you have breached your lease and they should have the ability to be able to reclaim possession of your home or your apartment. In a wrongful detainer action, the individual who owns the property claims that the person residing there is not there legally, that they have no agreement for rental or ownership of a particular property, and that they're there against the will of the landlord. Next slide, please. Thank you. So what you have in front of you are examples of 2 of these actions, and these are actions that among the most numerous that we have seen so far. One is the failure to pay rent. As you can see, that's it would be on the left side of the screen as I'm looking at it. And it says at the top, failure to pay rent, landlord complained for repossession of the rented property. And it cites a provision in the code, Real Property Code Act 8-401. On the right is a complaint and summons against tenant holding over. It also cites a provision of the code, Real Property Section 8-402. And the other actions are also, there are also forms that are provided by the district court, and those will be entitled at the top, breach of lease action, and the other will be entitled wrongful detainer action. Now, what's the difference and why does it matter? I'm going to start to get into that, and I'll leave off and allow Zephyr to come in and fill in. But just to start us out, as I stated before, in a failure to pay rent, the landlord is suing you to repossess the premises because he's alleging that the tenant failed to pay the rent when due and payable. How's the action initiated? The action is initiated by the landlord filling out this form, filing it in the court. The court then serves this complaint on the tenant. And you'll be served, and it has to be through these 2 means, by mail and by posting on or about the premises. Now, we say that should be posted on the door. Sometimes these notices are not posted on the door. Normally, there's no advance notice that's required in order to file these cases, but with COVID-19, and we'll talk about this a little bit later, that's led to a change for certain properties that are protected by the CARES Act. We'll talk about that again a little more later. The landlord may seek to get the rent that's due at the time of filing, as well as the rent that may be due at the date of trial, as well as court costs. Next slide, and Zephyr.
So the defense is to failure to pay rent and under normal circumstances are actually pretty varied. And don't believe anyone who says there's no defense to not paying the rent. It could be that the landlord doesn't have bookkeeping to show an accurate account of what's been paid and received. It could be that the landlord lacks standing in court, basically not having lawful operation of a rental property because they lack a rental license in the local jurisdiction, or that they lack a Maryland Department of Environment lead risk certificate so that they're compliant with lead risk laws throughout the state. Landlords are also required to assure the court that the person being sued, the renter, is not in active military service. And so if they don't provide information to show the court that a person is or is not an active service member, that case can be dismissed. At Legal Aid and Public Justice Center, we often see that landlords who are suing in the rent court with these fair to pay rent cases are corporations that no longer have good standing in the state, or are foreign corporations that aren't registered in the state of Maryland. They could be former owners trying to get rent out of somebody before a foreclosure or right after a foreclosure has gone through. The number one defense, however, I think that tenants commonly bring in a failure to pay rent case is about defective conditions in the property. And we're going to talk about one of the main defenses a little later in our presentation. It's called rent escrow, where a tenant pays rent into a court account in order to compel by court order the repairs to the property. And there's another defense, which is simply called a warranty of habitability, which is to say that the landlord has a promise in their contract to keep the property livable. And because the landlord didn't follow that promise, not all the rent is due. Next slide, please. So with COVID-19 has come a number of new protections that affect failure to pay rent. We're going to cover three areas of these protections. One, we're going to talk about Governor Hogan's executive order from back in April of 2020, which many people have called a moratorium, but it's actually an affirmative defense that tenants can bring in court when they show up, and it's related to whether there was a substantial loss of income due to COVID-19 or the state of emergency. Next, we'll talk about the Federal CARES Act, which was a federally legislated moratorium that also has restrictions on whether there's notice provided tenants before any type of eviction action occurs. There's been some federal agency extensions of moratorium, and we're also going to talk about local protections that were achieved during the past few months in different parts of Maryland. Next slide. So the COVID-19 defense, so to speak, under the governor's executive order, it exists, and you can bring it in court as long as there is a state of emergency. The day that there is no longer a state of emergency, according to the governor's administration, that's when this defense will fall by the wayside. But for the time being, this is a very strong defense that we encourage everybody to prepare to bring. It applies in all failure to pay rent cases. And what the order says is that a judge will not enter a judgment for eviction if the tenant can show that they had a substantial loss of income related to the virus or to the state of emergency. So if there's been job loss in your household, a reduction in your hours, the inability to work because you're taking care of a homebound school-aged child, those are some of the reasons enumerated in the executive order, but there could be more. I think this is something that can be broadly read. So if you had to take care of an elderly family member who could no longer be in a nursing home, for example, that would be an example of some substantial loss of income that you should show documentation of if you can. This order requires a tenant who brings the defense to show objectively verifiable evidence. There's no definition of that, but we can assume that letters from employers, from childcare facilities, termination notices, unemployment documents, there's a variety of types of documents, and we encourage you to think creatively and broadly about what on paper you can bring, what in an email you can bring to this type of defense. Now, it's important to realize, though, that everyone's been talking about moratorium, everyone's been talking about the executive order in this COVID-19 defense, but in no way has any change in law made it so that you don't actually owe the money. This order doesn't waive the requirement to pay rent. It simply protects you from loss of housing. And we encourage everyone to explore ways to create payment plans that reduce the potential harm of not having paid months of rent that comes due after certain protections are lifted. And keep in mind that regardless of what happens with an eviction case, a landlord is entitled to sue for a collections action based on unpaid rent. Next slide, please. And I'll pass this back to Greg.
Okay, so here's the second defense that some folks may have depending upon the type of housing that they live in. The CARES Act, which was an act of Congress that was passed back in March. There's actually CARES Act 1, 2, and 3, and there's the potential act that is presently before Congress in the Senate, which I believe they call the Home Act, I believe. However, in CARES Act 2, the federal government recognized that there would be this impending tsunami of eviction cases just simply because of the nature of the pandemic, with folks losing their jobs, businesses closing down, of course, people getting ill. And so as a result of that, the Congress in the CARES Act forbid the eviction of residents or tenants between March the 27th and July the 24th. If the property was a property that was covered under the CARES Act. And we'll have another slide that'll come a little bit later to tell you how it is you can determine whether or not your property is one that's been covered by the CARES Act. But just to run through a few of them, if you live in a subsidized property, a federally subsidized property, if it's a property that is financed in part by a program called the Low-Income Housing Tax Credit Program, if it's a property that receives federal subsidies through a program that used to be called the Project-Based Voucher Program. If you're a tenant and you receive what used to be called Section 8, now it's called the Tenant Voucher Program, then if you live in one of those properties, then you live in a property that is covered by the CARES Act. And again, as I stated, we will give you a link that will allow you to, on your own, take a look to see whether or not, in fact, your unit is one that's covered by the CARES Act. But the one warning that I would give to you is that none of these databases that we will send you to are particularly comprehensive. None of them make the promise that they're 100% correct and accurate. And so we would urge you, as I said in the beginning, and we'll say a little bit later, to contact those legal resources that will be given to you so that they can make that inquiry. So what does all of that mean? That means that between the time of March 27th through July 24th, that if the tenant was unable to pay their rent, that the landlord was stopped from filing and executing on a failure to pay rent action. Then, under the CARES Act, after that period of time elapsed, before the landlord could initiate an eviction action, he first had to send a 30-day notice to the tenant, advising that tenant that they're going to proceed under the CARES Act, I suppose, but that they were going to proceed to a court action to evict you from your home. Now, the Court of Appeals, because I would suspect, and this is only my supposition, and probably I shouldn't give it to you, but for whatever reason, the Court of Appeals decided to extend those CARES Act protections to all tenants. Not that you had, because it recognized, again, as I said, I suppose, the fact that it's, unless you do a property by property record search, limited title search, it may not be possible for the tenant, and not even the landlord perhaps, to recognize the fact that they are a property that's covered under the CARES Act. So they applied that to the entire rental inventory in the state of Maryland and forbid any failure to pay rents that be filed until August the 31st, September the 1st. It required each one of the owners or landlords to file what's called a certificate of compliance. That certificate of compliance says that it tells the court that you are property covered by the CARES Act, in which case the 30-day notice has to be sent out, and the court would go to the, when that case is finally scheduled for trial, they'll look to see whether or not all the procedural protections are given to those residents before hearing the case. And if you're not a CARES Act property, then you would state that in the certificate of compliance, and the court then would proceed with the failure to pay rent case. Except, of course, if the certificate of compliance that the landlord filed is incorrect, then you as a tenant have a right to raise those CARES Act protections. And if in fact the eviction was somehow initiated between March the 27th and July the 24th, or if the landlord had proceeded with filing the eviction action prior to the time for the 30-day notice to expire, the expiration of that 30-day notice, they filed it before the expiration, then that case, you would assert, we would assert, is filed prematurely, and therefore that the action should be dismissed. Sorry, I said certificate of compliance is actually called a declaration of compliance, so excuse me. Now, for failure to pay rent actions that are filed on or after August 25th, the court advised that a declaration of compliance is not required. That's the court's order and not the CARES Act. There are, in fact, legal scholars who would disagree with the assertion that the declaration of compliance is not required to be filed, or the declaration of compliance, what it does is really show the court that the landlord has in fact followed the law. And so we would say is that the landlord is still required to follow the law after August 25th. So that if you didn't receive the 30 days notice before the landlord initiated the complaint, then that's a defense. Next slide, please. Okay, so here we get to those databases, and it breaks out vouchers, project-based sections, tax credits, federally black mortgages, etc. And you may have heard that the president issued a executive order extending or directing to extend some of the protections that were in the CARES Act. Now, that's not completely correct. What he asked the CDC and HUD and other agencies to do is to look at it to see whether or not those extensions should be required because of the conditions that are occurring because of the pandemic. What the HUD did is through its single home FHA program, it extended the moratorium on evictions through December 31st. Now, those are only a limited number of properties, but still that's an important protection. And we would urge anyone who believes that they may be in a property that's covered by this FHA extension to contact the legal resources that you will receive notice of at the end of this presentation. Next slide, please.
If I could jump in, Greg. So since we're talking about failure to pay rent, the question of how much the rent is going to be very relevant for every person going to court to defend themselves. And there probably will be some debate about whether rent increases during the COVID-19 state of emergency are legit or not. And this is where we press the audience to contact your Department of Housing, contact your local county council or city council members to find out whether your jurisdiction enacted any type of rent increase freeze or prohibition on late fees. Off a list I have, Montgomery County, Howard County, Baltimore City, Prince George's County, Anne Arundel County. These are all areas of the state where increases in rent have either been banned or severely limited to under 3% to 3% or less, and late fees have also been banned during the state of emergency, plus some additional amount of time. For instance, in Prince George's County, this prohibition lasts 90 days after the state of emergency is rescinded. In Montgomery County as well. In Anne Arundel County, it's 120 days after the state of emergency. So those we can't list every city and county that's done this, but please make the phone call and find out before your trial whether there's any new protection. On the topic of rent, I'll skip to the next slide real quick. Rent escrow, like we prefaced, is a way to pay your rent into court. And there's a number of things that have to occur before you can do that. First and foremost is that the defects in your property that arose during the time that rent was due have to be serious defects that pose a threat to your life, health, and safety. Another important consideration is whether you provided notice of the defects to the landlord and have a way to show that. Although it's not required to have a certified mailing in every jurisdiction, it's important to have something in writing if you can do that. Showing that there was a reasonable opportunity to repair the property is another requisite. And then you have to show that after that opportunity, the conditions still exist, that the landlord refused to fix that, or the conditions just worsened. What's considered a reasonable amount of time for a landlord to come in is going to depend on different factors, but the law presumes that a 30-day time period is reasonable. That isn't going to hold in every case when defects are extremely severe and dangerous. The other thing is you have to know what to pay into court, and that's not going to necessarily be the amount of rent that the landlord says you owe in current rent or back rent. There has to be a determination by a judge about what's owed before you pay into court. And that means you have to have a hearing. You can raise rent escrow as a tenant either by suing the landlord in what's called an affirmative complaint, where you pay a filing fee, you make sure that the landlord gets served, or you raise it as a defense in a failure to pay rent case you state your case that because of defects in the property that weren't addressed, you're asking to do the rent escrow defense. We can go to the mediation and legal resource slides. Throughout the state, there is an option to use the district court's free alternative dispute resolution program. It's a mediation or settlement conference program. And all that means is that if you feel like you can work out a resolution to your case without having to go in front of a judge, then the district court services are there to help you and the landlord try to resolve through negotiation, which is completely voluntary. The district court ADR is holding these services remotely right now. In a different time, they would be at different district courts on different days. But right now, here's the phone number and the email address to try and obtain those services. And if you call the district court self-help center, which we're about to tell you about, they'll also refer you to mediation if that's something you think will help you. Next slide. So legal assistance and self-help resources, probably the most important part of our slideshow. The district court has ramped up its program of providing attorneys who are free and can provide advice, not representation, to renters who call 410-260-1392, 8:30 to 8 p.m. Monday through Friday. It's best to do this ahead of your trial, but even on day of, the self-help center is available by phone, in person at certain court buildings such as Baltimore City and Prince George's County, as well as by chat online. And you can go to this link, mdcourts.gov/self-help, to find the chat as well as the phone numbers and locations. There are a number of programs: Legal Aid, Public Justice Center, Pro Bono Resource Center, Community Legal Services of Prince George's County, that provide day of at court assistance. We expect that might be a little bit modified with the reopening of the court, but call any of those agencies, and some of them are listed here, to find out whether there will be free attorneys who are available to advise and represent at your district court, your fair to pay rent case at district court. We've provided a few other resources here to help you, such as maryland.freelegalanswers.org, where you can obtain, based on your eligibility, some answers online. And there's a long list of legal resources, not just for housing, but for many different issues at the Maryland Legal Services Corporation website, mlsc.org/news-resources/find-legal-help. And if you're a reader, you like to read, People's Law Library is an extensive resource of plain language, easily understood legal information about Maryland's laws and court process.
Thank you, Greg and Zephyr. That was some really helpful information that you shared with us. We do have some questions that have come in while you were speaking, and I'm going to provide you with those questions, and hopefully you can give us some answers to them. One of the questioners is asking about the right of redemption, and they've heard that there's a point in time where the court will not let you redeem your judgment any longer. Could you talk to us about that and how many judgments will kind of lead to that foreclosure of the right?
So this is Greg again. The caller has it correct. In the state of Maryland, a tenant has a right to redeem the premises after the court has judged that the rent is due and owing, and has ruled, in fact, that possession of the premises should be returned to the landlord. That can occur 3 times. And within a year's period of time, and during those 3 times, the tenant, if they have the rent, they can do what's called redeem or keep the premises. in most of the state of Maryland, it's on that fourth time that you may have a danger. The landlord may, in fact, file a document in the court, and they may check off on in that failure to pay rent document. If we could have looked down, it was a little box that says, is the landlord asking to foreclose the right to redeem? And so in the state of Maryland, that's more than 3. So on that fourth occasion, if they got judgment, then the court could rule that there's no right to redeem, so that even if you had the rent money, you're not able to stay in the premises. In the city of Baltimore, that moves to the 5th time, or that is more than 4 times the landlord would have to receive judgment. And then on that 5th occasion, they could file and ask for judgment, asking the court to block the tenant's right to redeem the premises.
Just an additional point, which is that the right to pay to stay and your right of redemption only occurs in a failure to pay rent action. So the other cases we talked about, like breach of lease and tenant holding over, there is no redemption time where you could correct a breach and stay or somehow pay after your lease is ended to stay. Those cases don't have that time to redeem possession.
Just to follow up to that, when you said a year, are you referring to a calendar year or 12 months?
Referring to 12 months, that is within 1 year from the date of the earliest judgment. And I'd also like to say that Zephyr is correct, of course, that the right to redeem does not apply to the tenant holding over or a breach of lease or to a wrongful detainer action. However, in a breach of lease, there's another test for that the court sets for the landlord, or the statute sets for the landlord. That is, that they prove that there was a breach, that breach was in fact substantial, and that breach warrants eviction. And so even if you have breached the lease, if breach is not substantial, or if the judge decides that it doesn't warrant eviction, then you may not be evicted. But I would say in all of those cases, even if the landlord has asked for foreclosure of the right to redeem, please, please, please go to court. Let the court decide.
Thank you. We have another question that asks about the warrant of restitution. This person is asking that they've seen a warrant of restitution, but it doesn't have a court date for a hearing, and there was no judge's signature. Could you talk a little bit about that?
So Zephyr, I guess I'll join in on this. So the warrant of restitution is the actual legal instrument that a landlord has to use in order to effectuate or to make good an eviction. They have that right to apply. It's called a petition, I believe, for a warrant of restitution after the tenant's appeal date in any of the eviction actions is finally expires. In the failure to pay rent, that's after 4 business days after the judgment was rendered, and in a tenant holding over and breach of lease, as well as in a wrongful detainer, that's a 10-day period of time. And I'm not sure why the document that you noted did not have a judge's signature on it. The judge is required to sign the warrant. It is, in fact, the court giving effect to the judgment that was reached and given legal permission to the landlord to evict you from your premises.
Thank you. The next question asks, or says that the landlord has filed a failure to pay rent. The tenant has paid a little bit of it, and the landlord has told them that they don't need to come to court. Is that true?
Well, we can't know whether the landlord is how the landlord will act, and that's really the problem for this tenant. They can't leave it to chance and assume that the landlord will make good on a vague promise. Going to court is the only opportunity for this tenant to hear what the landlord is really going to say, and then to have their own piece heard by the judge. We often hear from our clients that the landlord told them, "You don't need to come, you know, watch your kids, go to work, we'll take care of it." And weeks later, they find out there's a warrant issued to evict them. It's important to realize that a lot of landlords are good actors and make assurances out of good intention, but circumstances can change. Having an order to evict you and a warrant to carry out the eviction are their leverage. It's their legal leverage. And you have to expect that they'll use those instruments when they need to, when the circumstances change and they need to use it. So again, as Greg has said a couple times today, please go to court, defend yourself, have your voice heard.
Thank you.
Yeah, I can just add one thing to that. Sort of a corollary to that question is, what happens if the landlord asks you to sign something that says, in fact, that you owe the rent? I would urge everyone, before they sign any sort of document that the landlord may request that they sign, that they be very careful about that, extremely careful, and that you take advantage of the resource list that we've provided to contact the legal assistance and self-help resources to just get a little bit more information before you sign something. This is something that's really important, and you want to, if you can, take your time and get the best advice you possibly can.
Good advice. Next question talks about going to court. We've been encouraging everyone to go to court, and this person wants to know what they should expect when they go to court. Is it safe? What happens when you get there with COVID?
So I think I'm going to start out, and I'll let Zephyr jump in and share this with me. So we're urging everybody to go to court because this is a legal matter. No one can be evicted in the state of Maryland without resort to the courts, to an action being filed, to the court issuing a ruling and a judgment going to the landlord, and the landlord filing a petition for warrant of restitution, and that being signed, and the landlord finally having the legal right, after going through all of the steps, to evict. Now, when you go to court, the courts have instituted COVID-19 mitigation measures. Everyone is required to wear a mask. When you go to court, I understand that the court personnel will be taking your temperature to assure, in fact, that you're not currently exhibiting symptoms of COVID-19. There are rules that ask that folks be socially distanced. For instance, in the Baltimore City District Court, there are 2 elevators, and there's a sign saying that they want no more than, I believe, 1 person on the elevator at a time. Inside the courtroom, we've noticed, at least in several jurisdictions, that the courts are taking a hard look at scheduling, how they schedule the cases, how many cases they schedule into the court at one time. And that purpose is to try to keep a few people in the courtroom. It is an interior space, as is possible, so as to lessen the risk of COVID-19. There's a limit on being able to, from the court, being able to bring in others besides a witness if you do get summoned to court. So there are mitigation practices there. You have to keep your mask on when you're at all times when you're inside the court. Judge will have on a mask, as will the clerk and all other courthouse personnel, as will if you're represented by counsel, as will your attorney. And there are efforts made to try to make the courthouse a safe environment.
I'll just add to that, Greg, that it is your right to have an in-person hearing. And for many people, that is going to be the most assurance they have of being heard. But for people who have compromised immune systems, who are literally living after surviving the death of a loved one due to coronavirus and have no intention of exposing themselves unnecessarily, they have to consider whether going in person is safe or reasonable. And, luckily, the Maryland rules allow courts to hold remote hearings by phone or video conferencing equipment. And the Chief Judge of Maryland has issued guidance stating that the courts should allow virtual hearings, remote hearings, where it's necessary or more convenient. Whether that's going to happen and how it will happen in each of the different district courts and all the different jurisdictions is really not known right now. Today's day one of failure to pay rent actions. Failure to pay rent cases historically have been the last ones to be electronic or digital in any way, including in record keeping. So we're going to see what happens, but the main I think takeaway for those people who do not want an in-person hearing is to realize that they can request that to participate by phone or by some type of other conferencing technology. They just have to figure out how to get that point across. I think it probably starts in real terms. It probably starts with a call to the court clerk for the court where your case is scheduled. Talking to a lawyer, of course, too. Lawyers are probably going to know what the local factors are for trying to get that type of hearing.
Great. The follow-up to that is, if I have a remote hearing, what should I expect and what preparations should I make?
I think that, I'll just take a stab at this because there's so much we don't know about it. But I think having your records in some way digitized, even using a smartphone, if you have one, to take a photograph of the receipts or the rental assistance application or a page of your lease, whatever the proof is that you need to have to support your case. You want to be able to show that to the court, and they will probably only be able to take that evidence by email or some other type of online means. So having that ready, I think, is important. Making sure that you have the right technology, and if you don't, where to use it, whether it's through some public space that provides a hotspot, or some service through one of the internet providers that will provide low cost or free internet service. Those are the kinds of things I think that the courts will probably expect users, defendants in this case, to be responsible for.
And I'd only add that when Zephyr, if it wasn't apparent, when he talks about digitizing your exhibits or your proof, he means taking a picture, for instance, with your cell phone, or if you have the little, I call it doohickey or app, it shows my technical proficiency, to PDF the document so that you can share the hard copy of it with others. Then that would be the prerequisite to requesting, it seems to me, a remote hearing. This is brand new. And if you have a problem with your remote hearing, what I would say to you is please contact the legal assistance providers that are listed. We do have what are called post judgment rights. You have the right, of course, to appeal. You have the right to file a post judgment motion, and that's whether it's a remote hearing or just a regular hearing, an in-person hearing. So please understand that. We haven't talked about that today, but those are important rights that you have.
We're quickly running out of time, so if we could get quick answers on a few more, and we'll come to an end. One question asks if the courts will continue to provide proper summons to tenants to attend court in failure to pay rent cases.
Well, they have to provide tenants with the proper summons, or else the court doesn't gain jurisdiction in the matter. And by jurisdiction, we mean the power of the court to be able to decide the case. So in a failure to pay rent, that's by first-class mail and by posting. It's similar in a tenant holding over in breach of lease. I'll leave it at that.
Okay. Next question is, are late fees banned in Montgomery County between March and now?
I know Montgomery County did pass a law early on in the pandemic to cap rent increases, and I'm actually not sure about the late fee provision, if there was one included in that bill like other counties. I know this information is summarized on the Montgomery County .gov website.
Thank you. And I think we might have time for one more question. But before we get to that, I just want to remind people that if we didn't get to your question, please feel free to call the Maryland Court Self-Help Center at 410-260-1392 and speak to an attorney there, and they can answer questions that we didn't get to today. The last question we have, the person is saying that they heard that Baltimore County banned all evictions until after the state of emergency. Is that correct?
So this is Greg Callis, and I actually, when I heard it this morning, I was about to rise up out of my seat and, throw a little party. However, I've checked the internet. That doesn't seem to mean that this is not so, but I haven't seen any news that in fact has occurred. Zephyr, have you?
No, that's nothing remotely like what we've heard. There's an additional question here about what the timeline will be for evictions that were filed in Baltimore County after July 25th. I don't think either of us knows exactly. We're seeing that courts are reducing the docket size for these cases, which would extend the amount of time, I think, for evictions to be heard.
Right, and we're right on time. So thank you, Greg and Zephyr. This was definitely helpful and needed. I just want to remind everyone that this town hall will be posted on the Maryland Attorney General's website, which is marylandattorneygeneral.gov. And I believe it will still be available on YouTube for people to refer back to. Thank you all, and I just want to remind everyone, if you get a summons, please go to court and please contact one of these legal services providers as quickly as possible so that they could decide or see if there's any way that you could get help. Don't wait until the day of. And good luck, everyone, and thank you.